All right, good evening, everyone. I apologize for being a little late. I was a little delayed in my travels this evening. Also, due to my travels, I apologize, but I'm not up to date on my grading. I've not graded last week's assignment, but I should be caught up here by Wednesday or so. But tonight's class is going to be extremely brief, even by my standards, so you won't be in here for very long. Before we get started, does anyone have any questions about last week's assignment or any other assignments for that matter? All right, not hearing any assignments. The next step, if you recall, in last class we just finished submitting the case to the jury, and now if you're fortunate enough to submit the case to the jury and win, the next thing that takes place is you have to file a motion for the judge to sign the judgment. The judge, or you have to ask the judge to sign a judgment to include anything that you want in said judgment. That could be damages, attorney's fees, if it's that type of case. Could be something like specific performance, contract case, costs, anything else. Just remember, in your motion for judgment, if you don't ask for it and the judge enters a judgment without it, you have waived all basis and all rights in which you can recover it. You've waived your right to appeal it, so you have to ask for it. It looks something like this, just a very, very brief motion. Just a basic statement of the case in the first paragraph, the first section. You then state that you're attaching a judgment. The easiest way by far to ensure that you are asking for everything in your motion to enter the judgment is to attach it and to incorporate it by reference, which is here in paragraph B of section 2. That is by far the easiest way in which to make sure that you're not leaving anything out, is by incorporating the actual judgment that you are asking for. If you're on the unfortunate losing side of a jury decision, you can ask for a judgment non-abstente verdicto, or much more commonly known as a judgment J&OV. That's covered by the Texas Rules of Civil Procedure, Rule 301, in which you're basically telling the court, yes, I know the jury has decided against me, but I still should win for whatever reason why you believe that you think you should win. Either the facts are in your way or the law. If you're going to be filing a J&OV, it must be in writing. You must specify which findings you're asking the court to disregard. You must attach a corrected judgment, and you have only 30 days from the signing of the judgment in which to file it. The grounds for a J&OV could be no evidence. There's no evidence to support the judgment given. You could present to the court conclusive evidence to the contrary of whatever the case there is, or you possibly might have a legal bar, such as maybe a statute of limitations. There's an actual question as to when the statute of limitations began to run, and that was found presented in the evidence to be decided. These are really the only grounds for a J&OV. Let me just tell you, if you're filing a J&OV, you can almost assuredly feel like you're going to lose that motion. I would guess maybe 1 in 1,000 judgments, notwithstanding the verdict, are ever granted Just think logically, that court has sat there through a jury trial, allowed a jury decision, has actually signed a judgment reflecting a jury decision. It's going to be hard in 30 days to get that judge to change his mind. But it is a legal way to do it, and it does happen. So don't ever feel like you're just wasting your time. When you are going to be asked to file a judgment, to prepare a judgment for the court to sign, when you do so, it must state for whom, whose wins, who's losing. This is all covered in Texas Rules Civil Procedure Rule 306. You must dispose of all the issues and state that the judgment is final. That's for appealability concerns. This used to be a very, very complicated matter to get a final judgment. It's not nearly as final nowadays with their open jury questions. But sometimes when you get a very complicated case, multiple parties, it can be difficult sometimes to make sure that you are disposing of all of the issues in a case. If you're asking for money damages, the judgment must state an exact amount. It must state the exact amount of prejudgment interest in which you're entitled to. Just so you know that prejudgment interest in Texas is decided by the prime rate. It's either the prime rate is published by the Federal Reserve or 5%, whichever is greater. Then it must also state the interest rate for the post-judgment interest, which is the same interest rate as the prejudgment interest. Neither prejudgment or post-judgment interest is compounded. It is simple interest. If costs are recoverable, you must state against whom those costs are recoverable from. You do not have to put in how much the costs are. That is actually a duty of the clerk. The clerk will prepare a cost bill in which the amount of costs which are recoverable will be noted. And the judgment must have a place for the judge to date and sign it. This is the simple judgment in a negligence case. I encourage you to look at it. You can see that here that it's just a one-page judgment for the judge to sign, which covers all of those details. Following the signing of the judgment, the court has something called plenary power in which the court can change his mind. The court has the power to act for 30 days after the date of the judgment in which to change his mind. Now it can be extended for additional period of time, either by filing a motion for new trial, a motion to reinstate. That would be in a case in which the case had been dismissed, possibly it had been default judgment. You're asking the court to reinstate it. A motion to modify the judgment also extends the court's plenary power, and a motion for J&OV will extend the court's plenary power in which the court can change its mind and change the judgment. If something is filed in which the court's plenary power is extended, the court's plenary power will be extended for 30 days, and after that motion is overruled. Obviously, if it's granted and a new judgment is signed, that will start a whole different set of deadlines. If the court does not overrule a motion expressly, which happens very, very often, the motion will be overruled by operation of law in 75 days. So if you had to take your original 30 days and then extend the court's plenary power by an additional 75 days, the court has the power to change its judgment for a maximum of 105 days. After that 105 days, the court loses all power to change that judgment, and that judgment will become final unless changed upon appeal. There are certain ways in which to change the judgment even after that 105 days. Essentially, the only one that matters is a clerical error. You can ask for a judgment nunc pro tunc. The clerical error must be identifiable on the face of the judgment. If you can recall, I told a story about how I wrote the wrong year in a judgment in January. I wrote the previous year. I was able to change that by filing for a judgment nunc pro tunc and got that year changed. It was apparent from the face of the judgment that the wrong year had been noted for signing. After a judgment is signed, you also have a set of appellate deadlines. These are separate and apart from the court's plenary power. If a court's plenary power has not been extended from one of the ways that we mentioned, the filing of motion for new trial, for example, you have 30 days in which to file your notice of appeal. If a court's plenary power has been extended, you have 90 days to file your notice of appeal. These are not extended by the 3-day mailing rule. These are not covered by Rule 21A because you're not providing notice among counsel. This is notice from the court. You're assumed to get notice the same day that that is signed. So these are hard deadlines of 30 days and 90 days in which to file a notice of appeal. As I promised, this is going to be a super quick class. Our next assignment is here, which we were successful in our trial. We were awarded $350,000. I'm asking you to prepare a motion to enter the judgment and also to prepare a judgment. There you have the date of the judgment and the date pre-judgment interest starts. Before we conclude our very brief class, anybody have any questions? All right. Well, Clara?
Okay. In regards to the judgment, we have to attach with the plaintiff the document that says plaintiff motions to enter a judgment. We need to attach to that document the judgment of why the plaintiff win the case, right? All the arguments that we have on the case, based it on the answers that we got from the jury, right?
Yes, you can assume that the jury answered favorably for you. You don't have to make any argument in a judgment that you won. You can assume that the answer is clear on the face of the jury's responses. Does that make sense?
Okay. Yes, kind of. Well, I'm always this class.
Let me go.
The other question is.
Go ahead.
Can you repeat that because I kind of lose you at the end?
Okay, I brought up the screen, and this is a sample judgment. By the way, a very good sample for you to use. All you really have to state as far as whether or not you won or lost is right here in the first paragraph. It says, on the claim of negligence, the jury found in favor of the plaintiff. Really all that's necessary is that first paragraph. Anytime you win a case, it's going to be very apparent from the answer of the jury questions That's assuming that you've done a good job writing said jury questions, but we did in this case. Does that help you looking at the sample judgment?
Yes, it helped me a lot because I read everything before the class tonight, and I started to fill it out, you know, the spaces that in regards of our case. And I already made the amounts and everything. But the thing is that, you know, when you said at the beginning of the class that we need to make the judgment, the first motion, we have to, and in the first document that you attach, it says the attached judgment correctly reflects the verdict of the jury and all matters of the fact and of law in this case. So what I understood from that is that we have to attach something else to this document that is the final decision of the judgment. Am I right? On the grounds of what the jury decided, right?
Well, I'm not sure I'm understanding your question. What you need to do is essentially file a motion asking the court to sign a judgment, and you attach the judgment.
Okay. Okay. So the pre-judgment interest and the post-judgment interest are the amounts that we have in the judgment on the second page, on the other document, right? Because these are two different documents.
Well, they are two different documents, and those are two different numbers. That well, you only have to determine pre-judgment interest. You can't determine post-judgment interest because you don't know when the judgment's going to be signed. You just have to put in how post-judgment interest is determined, what the interest rate is.
Okay. Okay. I think I got it. Okay. Thank you.
Okay.
Okay.
All right. Anyone else? All right. I appreciate y'all coming in, and I hope that y'all learned a lot from this class, and I've enjoyed teaching y'all. And Claire, you have some more?
Not now, but for sure if I had something else, I will call you again.
Okay, you feel free to call me. And like I said, I hope that y'all learned a lot. I'm going to tell you, this is the assignments you've gotten are what paralegals do every day, and I feel like y'all should be getting a good grasp on getting out there and getting that first job. And if y'all ever have any questions about anything, y'all know how to get in contact.